Please subscribe, like and share this content. It means a lot to us. Thank you in advance. Cornell Law School. U.C.C. Article 3. Negotiable Instruments. Part 3. Enforcement of Instruments. Paragraph 301. Person entitled to enforce instrument. Primary tabs. Person entitled to enforce an instrument means I, the holder of the instrument, 2, a non-holder in possession of the instrument who has the rights of a holder, or 3, a person not in possession of the instrument who is entitled to enforce the instrument pursuant to Section 3309 or 3418 d. A person may be a person entitled to enforce the instrument even though the person is not the owner of the instrument or is in wrongful possession of the instrument. Paragraph 3302. Holder in due course. Primary tabs A, subject to subsection C and Section 3106 d. Holder in due course means the holder of an instrument if 1. The instrument when issued or negotiated to the holder does not bear such apparent evidence of forgery or alteration or is not otherwise so irregular or incomplete as to call into question its authenticity, and 2. The holder took the instrument I for value, 2. In good faith, 3. Without notice that the instrument is overdue or has been dishonored or that there is an uncured default with respect to payment of another instrument issued as part of the same series, IV. Without notice that the instrument contains an unauthorized signature or has been altered, V. Without notice of any claim to the instrument described in Section 3306, and V. Without notice that any party has a defense or claim in recoupment described in Section 3305, A. B. Notice of discharge of a party, other than discharge in an insolvency proceeding, is not notice of a defense under subsection A, but discharge is effective against a person who became a holder in due course with notice of the discharge. Public filing or recording of a document does not of itself constitute notice of a defense, claim in recoupment, or claim to the instrument. C. Except to the extent a transferor or predecessor in interest has rights as a holder in due course, a person does not acquire rights of a holder in due course of an instrument taken, I, by legal process or by purchase and in execution, bankruptcy, or creditor's sale or similar proceeding. 2. By purchase as part of a bulk transaction, not in ordinary course of business of the transferor, or 3. As the successor in interest to an estate or other organization. D. If, under Section 3303a(1), the promise of performance that is the consideration for an instrument has been partially performed, the holder may assert rights as a holder in due course of the instrument only to the fraction of the amount payable under the instrument equal to the value of the partial performance divided by the value of the promised performance. E. If I, the person entitled to enforce an instrument, has only a security interest in the instrument and 2. The person obliged to pay the instrument has a defense, claim in recoupment, or claim to the instrument that may be asserted against the person who granted the security interest, the person entitled to enforce the instrument may assert rights as a holder in due course only to an amount payable under the instrument which, at the time of enforcement of the instrument, does not exceed the amount of the unpaid obligation secured. F. To be effective, notice must be received at a time and in a manner that gives a reasonable opportunity to act on it. G. The section is subject to any law limiting status as a holder in due course in particular classes of transactions. Paragraph 3303. Value in consideration. Primary tabs A. An instrument is issued or transferred for value if 1. The instrument is issued or transferred for a promise of performance, to the extent the promise has been performed. 2. The transferee acquires a security interest or other lien in the instrument other than a lien obtained by judicial proceeding. 3. The instrument is issued or transferred as payment of, or as security for, an antecedent claim against any person, whether or not the claim is due. 4. The instrument is issued or transferred in exchange for a negotiable instrument. Or 5. The instrument is issued or transferred in exchange for the incurring of an irrevocable obligation to a third party by the person taking the instrument. B. Consideration means any consideration sufficient to support a simple contract. The drawer or maker of an instrument has a defense if the instrument is issued without consideration. If an instrument is issued for a promise of performance, the issuer has a defense to the extent performance of the promise is due and the promise has not been performed. If an instrument is issued for value as stated in subsection A, the instrument is also issued for consideration. Paragraph 304. Overdue instrument. Primary tabs A. An instrument payable on demand becomes overdue at the earliest of the following times. 1. On the day after the day demand for payment is duly made. 2. If the instrument is a check, 90 days after its date. Or 3. If the instrument is not a check, when the instrument has been outstanding for a period of time after its date, which is unreasonably long under the circumstances of the particular case in light of the nature of the instrument and usage of the trade. B. With respect to an instrument payable at a definite time, the following rules apply. 1. If the principal is payable in installments and the due date has not been accelerated, the instrument becomes overdue upon default under the instrument for non-payment of an installment, and the instrument remains overdue until the default is cured. 2. If the principal is not payable in installments and the due date has not been accelerated, the instrument becomes overdue on the day after the due date. 3. If a due date with respect to principal has been accelerated, the instrument becomes overdue on the day after the accelerated due date. C. Unless the due date of principal has been accelerated, an instrument does not become overdue if there is default in payment of interest but no default in payment of principal. Paragraph 305. Defenses and claims and recoupment. Primary tabs A. Except as otherwise provided in this section, the right to enforce the obligation of a party to pay in an instrument is subject to the following. 1. A defense of the obliger based on I. Infancy of the obliger to the extent it is a defense to a simple contract. 2. Duress, lack of legal capacity, or illegality of the transaction which, under other law, nullifies the obligation of the obliger. 3. Fraud that induced the obliger to sign the instrument with neither knowledge nor reasonable opportunity to learn of its character or its essential terms, or IV. Discharge of the obliger in insolvency proceedings. 2. A defense of the obliger stated in another section of this article, or a defense of the obliger that would be available if the person entitled to enforce the instrument were enforcing a right to payment under a simple contract. And 3. A claim and recoupment of the obliger against the original payee of the instrument if the claim arose from a transaction that gave rise to the instrument, but the claim of the obliger may be asserted against a transferee of the instrument only to reduce the amount owing on the instrument at the time the action is brought. B. The right of a holder in due course to enforce the obligation of a party to pay the instrument is subject to defenses of the obliger stated in subsection A.1, but is not subject to defenses of the obliger stated in subsection A.2, or claims and recoupment stated in subsection A.3 against a person other than the holder. C. Except as stated in subsection D, in an action to enforce the obligation of a party to pay the instrument, the obliger may not assert against the person entitled to enforce the instrument a defense, claim and recoupment, or claim to the instrument, section 306 of another person, but the other person's claim to the instrument may be asserted by the obliger if the other person is joined in the action and personally asserts the claim against the person entitled to enforce the instrument. An obliger is not obliged to pay the instrument if the person seeking enforcement of the instrument does not have rights of a holder in due course and the obliger proves that the instrument is a lost or stolen instrument. D. In an action to enforce the obligation of an accommodation party to pay an instrument, the accommodation party may assert against the person entitled to enforce the instrument any defense or claim in recoupment under subsection A that the accommodated party could assert against the person entitled to enforce the instrument, except the defenses of discharge and insolvency proceedings, infancy, and lack of legal capacity. E. In a consumer transaction, if law other than this article requires that an instrument includes a statement to the effect that the rights of a holder or transferee are subject to a claim or defense that the issuer could assert against the original payee, and the instrument does not include such a statement, 1. The instrument has the same effect as if the instrument included such a statement. 2. The issuer may assert against the holder or transferee all claims and defenses that would have been available if the instrument included such a statement. And 3. The extent to which claims may be asserted against the holder or transferee is determined as if the instrument included such a statement. F. The section is subject to law other than this article that establishes a different rule for consumer transactions. Paragraph 306. Claims to an instrument. Primary tabs. A person taking an instrument, other than a person having rights of a holder in due course, is subject to a claim of a property or possessory right in the instrument or its proceeds, including a claim to rescind a negotiation and to recover the instrument or its proceeds. A person having rights of a holder in due course takes free of the claim to the instrument.